speaker, Madeline Kimei, an experienced ODR expert. I am Nabila Rubayat, and I shall be the host for this webinar, which is being organized by CIADR. This webinar is the first episode of Season 6 of the ODR series. The CIADR webinar series is making a path to create an actionable community and ensure solutions to combat the future economic crisis in the global community. Now, a little bit about CIADR. CIADR is a nonprofit organization for alternative dispute resolution that is dedicatedly promoting and settling disputes through ADR mechanisms, namely arbitration, mediation, adjudication, and negotiation, with a group of experienced, qualified, and prestigious national and international ADR practitioners who are ready for providing the best ADR services to the global community. It is also the first and only online dispute resolution institute in Bangladesh. CIADR provides very natural, reliable, and cost-effective dispute resolution services in Bangladesh since 2018. CIADR is now renowned for its very cost-effective, fast-rating dispute resolution and very experienced independent arbitrators and mediators in South Asia. The CIADR and new branding identity, ODR institution, envisions their persistent passion to spearhead a new era of ODR development, both for the CIADR and global ODR ecosystem. CIADR aspires to be an uninterrupted provider of premium institutional aid as a tangible and independent venue for the conduct of domestic and international ADR and ODR proceedings. Now, I will introduce today's speaker for this webinar. Madeline Kimei is a practicing commercial and corporate lawyer. She is an arbitrator and mediator on the panels of Shanghai International Arbitration Center, Tanzania Institute of Arbitrators, and National Construction Council, and has experience as an arbitral secretary. She has a liking for tech and is known for developing the first online dispute resolution platform in 2015 named iResolve Tanzania. Her focus is on reshaping the delivery of ADR services for the future demand and increasing access to justice. Madeline earned an LLB from Coventry University and LLM in Law and Finance from Bournemouth University, UK, and a diploma in legal practice and is a practicing advocate. Madeline is also an accredited civil and commercial mediator by the Chartered Institute of Arbitration, UK, and also holds a certificate in dispute management from Indian Institute of Arbitration and Mediation, certified by the IMI Ireland. She is a member of the ICC Council of International Court of Arbitration and vice chair for the Tanzania Institute of Arbitrators. She has knowledge of the ICC rules and procedures and the UN Citral Model Law and its rules of both mediation and arbitration. Madeline is actively participating and promoting arbitration and other ADR mechanisms in Tanzania and as an ADR enthusiast. Madeline also writes and speaks on dispute resolution topics. As a commercial mediator, her approach is result-oriented, both in terms of problem solving and in terms of party satisfaction. She has also engaged as an ADR consultant in the design and implementation of the ADR Center to be based in Dar es Salaam by the Tanzania Law Society, currently in progress. Now, a little bit about our webinar today. The topic of the webinar is how to be a good ODR expert. Our webinar will be conducted in two parts. First, our speaker will be sharing her insights on how to be a good ODR expert, and then we will be taking questions from the audience. Feel free to share this live stream on your timelines and other groups, and do drop your questions in the comments below, or let us know where you're joining us from. Lastly, a little bit about your host. I work for a law firm as an associate. I'm also serving as an editor of Dhaka Law Review, and I am also engaged in nonprofit work. I will now be handing over the floor to our speaker, Madeline Kimei.
Thank you so much, Nabila, for that very, very impressive introduction to the work that CEDAR has been doing since 2018, and their mission to create an innovative ADR platform in Bangladesh. And your work, of course, as an associate and of course as a philanthropist, I would think, within the field of law, I appreciate it, and I am glad to be part of this well thought out webinar today on ODR experts, how to become an ODR expert and how to build your practice in a means that would embrace technology, bearing in mind that this is where we are going. This is actually what we have realized by the outbreak of COVID-19 and the need to observe social distancing when we are carrying out services as mediators, as arbitrators, or even legal advisors in our legal practice as commercial lawyers or otherwise. So thank you so much for that introduction, and I will just try to switch on back to my PowerPoint slides, and you can let me know if you can view the slide in front of you.
It is.
Thank you. Thank you. So then, after that introduction by Nabila, I don't think I have to go through this slide here. So I'll pass it over and get right to the gist of it all. How do we build our practice or create that pathway, the strategy on becoming ODR experts? It takes practice. I think in all means, it takes practice for one to become able, and not only able, but to become a professional in any field of practice. And ODR is no exception. Now, I'm going to take you back and give you maybe a little quote from one of the key players in driving ODR in our global community. His name is Colin Rule. Now, to become an ODR expert, they have to learn about what ODR, where ODR started off from. And this is Colin Rule. He was working for eBay in the 1990s, and eBay was one of the first platforms that created an online settlement process for those commercial consumers who were taking advantage of the access to purchase or to enter into electronic contracts on a platform such as eBay, where inevitably there were disputes that would arise. Now, what he said a couple of years before that, he said, we see a bright future for ODR, a future which the value of ODR to all is obvious, that we will only one day say, what took us so long? Now, this is a question I ask myself now. It only came about that ODR is being fully embraced now, not only in the developed world, but also in the developing world, by the outbreak of the COVID-19 pandemic. Now, we are left with no choice but to embrace ODR and take part and apply it in our day-to-day lives, in the sense of conducting our online mediations, conducting virtual hearings for arbitration, and we will come to that, how it has developed over the past 6 months, and how we have sort of leapfrogged the entire process due to this pandemic. Now, just a bit of background, which I've already shared, is really the origins of the online groups, online dispute resolution. There was a creation of a UNICITRAL working group. If you can see my bullet point and the historical evolution, is that this particular group was created under the UNICITRAL, and I think we all understand where the UNICITRAL comes from. It's a wing of the United Nations which deals with trade and commerce, and developing that area in order to create a conducive environment for businesses and consumers and the likes. Now, this working group 3 was charged with the task of looking at online dispute resolution and how one would be able to improve the regulatory and the legal frameworks attached to it. And they worked between 2010 and 2016, very renowned persons within the field who then recommended the technical notes on online dispute resolution, which we will speak about later on in our slides. But before we get to that, what is ODR? One, in order for us to say we're experts in ODR, we need to understand the definition of ODR. We all understand that it sort of terms out of alternative dispute resolution, or some may say appropriate dispute resolution. What is appropriate? What method is appropriate to apply to a particular dispute? That is the question one answers himself. Now, in essence, you ask yourself, what is the O4? So the O4 is for the online aspect. The fourth party, they refer to this as the fourth party in this spectrum. The fourth party that plays a role in the dispute resolution mechanism that is appropriate to this would be the technology. Now, how big of a technology can one think of? It's the internet. We started off with websites. We started off with email exchanges, communications via telephone, streaming live videos as we're doing today on using video conferencing, and other information technologies which are continuously continuing to come into place. We have now virtual courts where systems have been developed for virtual court systems, such as in Tanzania, we now have or electronic filing applications that advocates are encouraged to use when they're filing their disputes or their plaints into the courts of law. We have an electronic filing system that was supported by the World Bank, and it came into operation. And that is really, really cutting our work into half for those advocates who are placed in different areas of the country. Now they can do their work from their offices by using the e-filing solution. Now, at the outbreak of the pandemic, also the courts introduced, and in various jurisdictions, not just Tanzania. I've seen it happen in Singapore. I've seen it happen in the Americas, in the UK. So across the globe, virtual courts have had to come into place for the court to be able to conduct its business. Otherwise, everything would have come at a standstill, and we understand that backlog and clogging of the courts would have been at a place where we would not want it to be. Now, the American Bar Association there, as you can see, says ODR is a broad term which encompasses many forms of alternative dispute resolution, incorporating the use of the internet, websites, email, communications, streaming media, and other information technologies as part of the dispute resolution process. So this is an open-ended, an open, broad sort of definition, because it's got there and other information technologies. So, your mind is not left to sort of stay at a narrow place, but in a broader way. There's blockchain arbitration. Blockchain is a new technology. It's an artificial intelligence that one have to understand the complexities of ICT in order for you to understand how it works on the back end. But on the front end, you can see that it's a systematic way of approaching smart contracts, which are really what we're witnessing at this moment in time in our electronic commerce world, where now parties are entering into contracts in a smart way. These are called smart contracts. They're automated contracts. And we'll speak about this again in my other slides. Now, I wanted to go further and give you a slide that will really just summarize the definition of ODR. So as I say, ODR grows its term. It grows from the themes and the concepts of the alternative dispute resolution. And we know the spectrum. The ADR spectrum spans out from negotiation, mediation, arbitration, there's the mutual evaluation, there is the actual litigation itself that could also take place in an online system. ODR is the use of information and communications technologies to help parties resolve their disputes. We understand that from the definition by the American Association. Now then, if we go to the third bullet point, ODR is a form of online settlement that uses alternative methods for dispute resolution. The term covers disputes that are partially or fully settled over the internet, having been initiated in cyberspace, but with the source outside it. This is a very, very good look at how ODR works, because this is the reality of it. And this is a definition from a book that I would recommend each and one of us who's attending this seminar today to obtain. It's available on Amazon. It's by Abdul Wahab, Catch and Rainey, a 2012 edition. It's a fantastic text that you could refer to. And why they say it could be done offline and online is that, in our environments, especially in the developing countries, and in Tanzania specifically, and I know I've been to Dhaka and Bangladesh, and parties are yet to form that acceptance of the of trusting the technology fully. Now, if it's a partial, if we're speaking about a partial online dispute resolution process, that means they could accept that, my claim or my pleadings will be exchanged with the arbitral tribunal or with the mediator. The mediation brief will go to the mediator by use of email. I'm happy with that. But the actual session with the mediator or with the arbitrator, that's where we find a bit of a friction when it comes to cultural acceptance of the online environment. Not only cultural acceptance, but also we'll speak about other factors that drive certain parties to not be comfortable with the online environment, especially looking more carefully on the developing countries in Africa and in Asia. I go further with this, and I think you would see that I am concentrating on defining ODR because there are usually a big mix-ups on defining ODR. Now, pioneers such as Kim did ODR as the fourth party. If you can remember at the beginning of this seminar, I said something about the fourth party. This is now describing the status of technology in the ODR process. In ADR, the traditional mechanisms that we're used to, that are physical face-to-face meetups, we would not explore the relevance of the fourth party. But in ODR, we have to be able to factor in this fourth party, which is technology. There have been advancements, and there are more defined terms within the field of ODR, and you can catch them up and look them up. For example, electronic arbitration agreements, electronic filing, electronic administration. These are institutions that are, such as what CEDAR is doing, and qualified neutrals. Now, they can do this using electronic means. There are e-awards. This is a very controversial issue that is being discussed within these scholars and who are concentrating on developing ODR, electronic awards and electronic enforcement. How then, under the New York Convention, if we are aware of New York Convention on the recognition and enforcement of foreign arbitral awards, how can those foreign awards be enforced by the use of online or electronic platforms availed to parties? Now, understanding the ODR concept in a conventional way takes us back to the technical notes. And I'll skip this slide. I just want to introduce the UNICITRAL technical notes on online dispute resolution that were released in April of 2017. Now, these UNICITRAL technical notes, if I could jump to to the slide. These Unisatro technical notes on ODR are very important for us as ODR platforms or the forefront, because now they provide for a descriptive document of a non-binding nature. Now it's not binding on persons to make it mandatory. This is a non-binding document, and the technical notes came out of the work of working group 3 that I spoke about under the UNICEF. This descriptive document is neither exhaustive nor exclusive, as you can see in paragraph 3. The notes are intended for use in disputes arising from cross-border low-value sales and all service contracts concluded using electronic communication. This is what it says in paragraph 5. And to promote the development of ODR by providing assistance to ODR administrators and platforms, as well as to neutrals and the parties to ODR proceedings. This is what you see under paragraph 3. Parties organize their ODR proceedings in accordance with the technical notes. They choose to. Now, that binding nature, that means they can tweak those notes to their liking, and having to agree on the exact details and elements of the proceedings in this respect. Moreover, ODR providers may use technical notes and guidance to set up their rules of procedure. This is what we had to do after developing iResolve, the portal itself. We developed it in 2015. And so in 2015, when we started iResolve, and I wish I could go and show you how iResolve works, but I might, make a mess in our webinar. But when we developed it initially in 2015, it was more of a very static platform, in the sense that parties could exchange their documentations with the neutral who has been allocated to the neutral. Parties could have an open chat room area where it's a closed chat room area where only those who are had consent to take part in that particular matter would have access to. And then, of course, there were other things that they could do within the platform to allow them to exchange information and so on and so forth. But they could not conduct the hearing if there was going to be a hearing in the iResolve platform. What they would have to do is that they would have to arrange for it within the platform, and then they would have to come off the platform and use platforms such as Skype, Zoom, Opus, and Microsoft Teams, and WebEx, the whole shebang. And they will use those sort of platforms to conduct the virtual hearings if need be. Now,
so is this to say that the use of ODR came before the conventions, because the convention UNICETRAL of 2017 happened afterwards, but then your organization, it started in 2015. So it was informally there, but the convention and everything else followed afterwards in line with the technological revolution.
Yes, that's very right, Nabila. The UNICETRAL model technical notes came in 2017. ODR has been in place since the 90s. The ODR has developed over time very rapidly since the 90s. However, it was a self-regulatory field. It's a self-regulatory field where parties really, where the players really leave it to soft law or rules and procedures and guidelines that had been developed over time to guide them in this process. So with that being the fact, the technical notes were really, really welcomed when they came about in 2017. And most ODR administrators wanted to take into account these technical notes so they could have the credibility, they could build the trust, and they could be as transparent as what is being pushed for under the technical notes. So ODR may be read in two ways, as the either online resolutions of disputes focusing on the method of resolution, or the resolution of online disputes focusing on the type of disputes. the formal reading of online resolution of disputes seems to accord with the conventional understanding of the word. So what we would really welcome is that this is the online resolution of disputes as per the University notes. And Section 5 of that say provides for the ODR definitions, roles and responsibilities and communications as online dispute resolution ODR mechanism for resolving disputes through the use of electronic communications and other information communications technology, confirming that it's an online resolution of disputes. Now, the essence of ODR, this is also a critical factor because now this is building the pillars of ODR. And Catch and Risk in their book state three important factors, namely convenience, trust, and expertise, professionalism, forming essential parts of ODR. Other essential factors could be affordability and easing up the access and increase of justice, accessibility, effectively facilitating and not limiting the right of representation for parties. It has to be a secure means, hence preserving data and privacy rights, confidentiality provisions, flexibility, having that creative, flexible means of accommodating, very important for a successful ODR process. And enforceability. This is a question that we get from all our clients. What is the end of the road do I gain? Will they be able to enforce the electronically mediated settlement agreement? Will they be able to enforce the electronically obtained arbitral final award? This is the question that you get at the end of the road. And from Catch and Rule, they actually had the pillars there shown in color code telling you trust has the highest degree of necessity. For one to embrace ODR, what that portal, that ODR provider has to have a level of trust for parties to say, okay, this is the place that I can channel the dispute. So we spoke of the UNICITRO technical notes, which came in 2017, and we spoke of the self-regulatory approach that has been taken for ODR. Why is there a self-regulatory approach? This is because you do not want to create a fence when you speak of technology, because technology is full of innovation, and with laws which are strict, that would prevent its growth. It would prevent its application as well, in order for us to see growth. And so it's a self-regulatory approach that we're seeing being taken on ODR. And we're really relying on bespoke institutional ODR rules. And these are just rules of procedure in order for that particular ODR portal or platform to build trust, to be procedural outlines for the parties to follow, and neutrals to be able to adhere to. There's also the UNICITRO Model Law on International Commercial Arbitration, which is very technology friendly, especially the revised edition of 2006. You've got the New York Convention, as I spoke of, with also aspects of accepting electronic means of carrying out and obtaining your arbitral awards. And you also have to look at the applicable laws or the governing laws of the country to which your dispute is subjected to. You need to look at the ICT law. So, the framework of the technology laws that are affecting those need to be well reviewed for you to have a robust, accepted ODR platform or ODR practicing electronic transactions laws, electronic evidence laws, and cyber laws. All these factors that need to be considered when you're conducting an ODR process, whether be it an online mediation or an online arbitration. One needs to be able to understand and review the laws that are attached to this particular process in order to ascertain the legal risks associated to the process in respect of your different jurisdictions. Now, I spoke of a really good question from Nabila, how then were we working before? If there was no technical notes as of 2017. So we've got some references here on the slide, and the slide will be shared with you, referring to the Electronic Consumer Dispute Resolution Rules of the ODR, which are the European wing of the Consumer Dispute Resolution Platform, the China International Arbitration and Trade Arbitration Commission Online Arbitration Rules are very good to look at as well. They really offer you at least a view of how these rules should be aligned. We've got the Hong Kong International Arbitration Center Electronic Transaction Arbitration Rules, the eBay Online Mediation Experience that was conducted under the Colin Rule team, the E-Commerce Mediation Center from the Koreas, and the International Center for Dispute Resolution, ICDR protocol for manufacturer and supplier disputes. These are just examples of the rules. There are certain standards also developed over time, such as the American Bar Association, and this is not an exhaustive list. I have just put these here, examples of standards that one could refer to when they need some that happening, when they're building their knowledge further after this webinar. So the American Bar Association Task Force on E-commerce and ODR also have the recommended practices for ODR service providers. The European Committee of Standardization also came up through a workshop sometime in 2007 on standardization of ODR tools, which are very handy. They come in very, very handy for ODR platforms. ICC also had best practices for online dispute resolution in B2C. This is business to consumer and consumer to consumer transaction. This is dated back in 2003. And as I know, the ICC are reviewing these to come to sort of update them to go hand in hand with what has happened over the past couple of months with the pandemic. Then one could ask you, what kind of disputes are able to be resolved through online means? Now, we can go a whole works. I've listed a few there, but this could be really backed down to actual dispute resolver who is assigned to that. If the neutral feels that the dispute is not commendable to use online platforms, then this should not be an online process. If they feel that the particular dispute would not be effectively managed through an online process, then they should advise the parties of having the physical or dispute resolution or face-to-face traditional means of resolving their disputes. Also, the consent of the parties is very important. For you to employ or deploy the fourth party, the parties to the dispute must agree to the process. The parties to the dispute must have somehow given the green light to the arbitrator, informing him that they were happy with conducting a virtual hearing. If you do not get that, the process could be challenged later on in the courts of law, especially when you're about to enforce your arbitral award and the challenge comes up from the respondent saying that the arbitration was conducted in means which we had not consented to. What are the benefits of online dispute resolution? One can resolve disputes generated offline and online, as we saw when we were defining that conventional aspect of the unicitral arbitration, unicitral technical notes. So it doesn't have to be just online disputes, but it could be also offline disputes. Disputes can be settled online in a simpler, faster, a low cost or cost efficient way. Because in the conventional world or in the traditional means of conducting things, you would find attorneys having to travel, experts who were witnesses in arbitration having to travel from their location to the destination or the seat of arbitration, and so attorneys' fees will also be higher, and so on and so forth. If they have to communication costs and so on. So this lowers that cost tremendously. Parties have more control and flexibility. Well, that is a benefit. That could be a disadvantage, and we would look at it in the next slide. Voluntary, need not to submit to laws of another country for dispute resolution. So this is a voluntary aspect, as we spoke of. The consent of the parties is important. Releases pressure on the judicial system. This is from Lord Justice Briggs. Yes. So if more, so I mean applying dispute resolution, online courts, we've seen the development of something called JOR. If you Google search JOR, it's a virtual court. That releases the pressure for the judicial system. Standardization of the redress and increase to justice. This is very true. Online dispute resolution does offer access to justice. It means that we have never imagined before, because from your phone you can access an outcome provider, an institute, and have that chat through a trustworthy process for its resolution. So from the phone, so you do not have to travel from a different location to access the courtroom, which is basically 100 kilometers away from where you are. You just do the filing, as we say, for electronic court filing from the comforts of your own home, from your phone, as we have witnessed over the couple of years. What are the disadvantages before this? Some have argued that there is an impersonal aspect of the process. Now, this really comes about where you get certain arbitrators who feel that it is very important for that face-to-face meeting to happen. Because with a face-to-face meeting, you really get to see the persona or the person in front of you and get to understand them in a better light. They're right in front of you. You're able to read the cues come from out of their reactions when you say something, when you ask them a question. But in an ODR platform, if the ODR platform has not given you a 360 view of who you're talking to, the witness that you're being you're cross-examining, you might not get the full picture of that particular person. Then there's knowledge of computers, and this is very important because, especially in the developing countries, where we have certain people who do not have knowledge of the use of computers, laptops, and these other technologies. Now, this is, of course, a lot of people have sort of stretched, and that gap is decreasing. But the elderly or the elder generation might find it more difficult to use technologies such as ODR platforms that are coming about, as opposed to the youth. Now, and if we look at the youth numbers in Africa and Asia, the youth numbers are huge. So our populations are made out of the youth. 70% of the populations in the developing countries come out of the youth, and so therefore this disadvantage could be just a disadvantage on paper, because at this point in time for Africa and Asia, those who are using technology are the youth, and the youth is 70% of its population. And so that is it's a very good point to have in that ODR is really going to be going up as we move to 2021 and 2022. I think it will be at its peak because of the fact that most of the people are embracing technology, and so therefore online resolution.
I have a question. Since you mentioned that one of the disadvantages is that it is impersonal, so how do we portray our emotions, and if not, how do we address that if we cannot show our emotions?
Yes. So with the impersonal nature, it really now comes to the management of the process by the neutral. For example, if it's a mediation, managing the impersonal aspect of the mediation would be to, prior to the mediation session, for the mediator to have some sort of pre mediation conference with the parties to build that trust and rapport with the parties and their counsels and their representatives, and having and ensuring that parties are comfortable with the process being online. The in-person nature of it is really now the mindset of the parties. So if you are able to build rapport and trust in the process, ensuring that the parties understand technology and are able to use and deploy the technology, that could sort of break the chains as to the personality of the tour. So you get to know your parties, the representatives, prior to the actual mediation session. It's not a big surprise for them when they sit with you that day on online media to conduct their case. And so that impersonality also comes a bit, it shreds off a bit. Also with the impersonality aspect of online dispute resolution, this is constantly changing. As I said when I was talking about knowledge of computers, the youth have really taken up technology. I mean, let's look at Facebook, the numbers on Facebook, the numbers on Instagram, the numbers on other social media platforms. We really are feeling the, we've broken the walls of virtuality in the sense that we feel as if we're with the other person. So the mindset has slowly changed over the years, and technology really is no longer impersonal, but it's personal. So I hope I answered your question, Nabila.
Yes.
So because there is no physical appearance of any of the parties, yes, it will form some sort of friction if you do not have that pre-engagement with your parties.
It's about the communication.
Limit.
Yeah.
Sorry?
If we can build that communication beforehand, so it's not going to pose as a barrier afterwards.
Yes. So, because at the end of the day, during the process, you will not have a lot of control over the parties. You can, yes, of course, with the features on the platform that you choose to use, you can mute some of the parties, you can opt to, to try and control, but you would not be able to sort of control the tempers and the tones of the parties from your home office. So it really is the use of the technology that would assist you to control the challenges that would come about due to the impersonal nature of the process. Sorry. So the limited disputes. I write this here because this is what we have seen. Limited disputes in the sense that we, for example, the iResolve, I like using iResolve as an example, is that only a certain number of disputes will be channeled through an online platform over the years. But now in 2020, this has very much changed. But the disadvantage before 2020 was that it would be very it would be very unique for a dispute to accept, or the parties to a dispute to accept a full-blown online dispute resolution process. But after 2020 and the pandemic, the impact of the pandemic, we're seeing this to change, to have changed, and we welcome this change very much, because now the disputes are not limited to just the value or the type, but also to a range of other types of disputes that we have never seen before. And so that disadvantage could, if I do a presentation again, maybe in 2021, could be an actual advantage. ODR versus litigation. I think this is for lawyers who are attending, they would really see the value of ODR against litigation. Qualitatively distinct from the judicial process, yes. We understand the judicial process is very stringent in its ways, and we have the civil procedure codes in common law countries, which has to be done to the letter, and the process of litigation itself is very much so hindered by the rules of procedure that are set by our laws. And so with ODR, as we say, it's a self-regulatory space. Dispute resolution mechanisms, those are applied, which is mediation and arbitration. The principles remain the same as if it was offline. Even if the fourth party comes, yes, the fourth party technology, but the principles of mediation that you learned as a mediator, or the arbitration skills that you learned as an arbiter, apply in the online world as if it was the offline world. The second bullet point there is that it can be initiated and terminated at any point of time. Yes, we understand this by the mutual consent of the parties, or in a mediation where one would feel that that was not going anywhere. Mutual third party with the parties on choice settles the dispute, yes, in the dispute resolution field. Proceedings are informal without procedural technicalities, as I said earlier. Proceedings are conducted in the manner used by the parties, or as per ODR institutions set as rules, not laws, sorry about that letter there. It says it should be rules, institutional rules of ODR. Confidentiality of the subject matter of dispute is maintained, very much so, and that's why the systems or the ODR platforms that one uses are recommended to have the highest security features in order to prevent confidential information from leaking. Reduces acrimony between the parties and encourages customer loyalty, especially when you talk about business to consumer, because the disputes are resolved in a faster, more economical means, especially when you talk about e-commerce, where everything is usually at the speed of light. And if you take that matter to a commercial court to resolve that dispute, that will take you a couple of years before you could see any fruits from that litigation. And so the ODR versus litigation, the advantages are really leaning towards the online dispute resolution. This is a table that I had wanted to share, and it really just summarizes what I said from my last bullet point, where you find that if it's an electronic commerce dispute, you do not want to take it to the traditional courts. You would definitely want to recommend to your clients that the online dispute resolution is the way that would be faster, cheaper, better, and convenient. Some applications, examples that the participants can look at is the virtual magistrate project, which is applying arbitration exclusively to disputes regarding offenses of dignity and personality by means of online publications and cases of theft. And this virtual magistrate project, you can read more about it, and they've got a website. The online, of course, another great example, and a great example that really works very well is the IPO system. The WIPO, the World Intellectual Property Organization, yes, the WIPO has a very good system for domain name disputes. Now, if we understand what domains are, which are really the website that you have, so www.iresolve.com is a domain name. Now, where you find that there has been some infringement of your domain name, which really comes about if somebody replicates it and infringes your IP, your intellectual property over that domain, then you have a dispute. Now, the WIPO will have a very good dispute resolution process that is purely online. And this particular online arbitration process has worked miracles over the years and has been very successful because the parties would submit their claim for breach of domain name infringement, and that will take place through the exchange of the neutral and the parties, and everything would be conducted online until the decision is then also published online in accordance to the UDRP policies. The UDRP policy really stems out of the Internet Corporation for Assigned Names and Numbers, the ICANN. They developed the policy for dispute resolution of domain name related disputes. We spoke of the Ecuador, which is ECODIR, which is the European Consumer Dispute Resolution application. That is also a very good application that one can look at and see how it works. And the challenges over my presentation, I think we've come to learn of these key challenges. And one which was highlighted by the dealer was the fact that there is no legal recognition of ODR clauses or a legal framework that has been set over the years that is a solid legal framework for ODR or a unified framework in that sense for either the B2C contracts or the offline, online disputes that we're referring to in terms of commercial disputes over the online dispute resolution portals. It is difficult to maintain or monitor the standards and quality of a portal. Why? Because technology is constantly changing and people have different asks. Over the years, the asks keep changing, and that really is coming back now to the strategy that the ODR provider has. So for an ODR provider to be very successful, they would need to have some sort of a feedback form. That feedback form will really tell you the feedback from the users, and so that you could learn how to improve the portal or the platform to go hand in hand with the users' recommendations. Because for now, for example, the users of, if it was iResolve, they would recommend for iResolve to have its own virtual hearing facility, that they do not want to have to go off to use other platforms for them to carry out a virtual hearing. And so therefore, that is the kind of maintenance and quality of standard that one needs to constantly keep up with over the running of their platform and of their practice ODR providers. The process poses a risk of reducing the levels of accountability and impartiality of neutrals and arbitrators. Yes, one could say this. The risk of reducing the levels of accountability. You know, the physical, traditional means of dispute resolution have always required us to have a level of accountability and impartiality. Yes, but now what happens in an online environment? What happens in an online environment where one is more relaxed from the comforts of their home? So there is a risk there where one would be a bit too relaxed to come to terms with the fact now that they have to have the same levels of accountability and the same levels of impartiality that is expected of them as neutrals, be it a mediator or an arbitrator. Now, where ODR is a non-binding process, for example, the only part of negotiation or mediation, it cannot produce legal precedents. However, if the legal step of ODR process, or the last step of ODR process results in an application, a legal precedent may be set. This is, this talks about the non-binding nature of certain processes. And so this is a two-tier dispute resolution process, or we call it MED-AB or hybrid. These are hybrid processes. Now, when it comes to hybrid processes, the ODR process provider has to be able to identify the last step and the result of that step. Because now they would have to be able to mold that process in that means, or in order to achieve what the hybrid process clause has provided. Insecure platforms pose the risk of confidentiality. We spoke about that. All parties would be required to have adequate technology to participate in the process. Parties without adequate technology may be at a disadvantage or unable to fully participate. This is a great fear when we spoke of the knowledge of and capacity of parties. Lack of personal interaction, we spoke of the government face query, where we say there may reduce chances of settlement. It could reduce chances of settlement, because if the neutral is unable to build rapport, build trust, and facilitate the process of settlement in an effective way through the online environment, this could pose the risk of the parties not arriving at a settlement as emphasized. The cybersecurity scare is one of great importance for us all, because we've seen, for example, Zoom bombing. There's a great article written in March last month where they experienced something called Zoom bombing, where you get hackers come into webinars and at certain other conference meetings that are being conducted online. So this is a very big scare for us all who are practitioners in ODR. Of course, the technical notes, if you look at them, they're very silent on the aspect of cybersecurity. But if you look at international arbitration centers or associations such as the ICCA Protocol on Cybersecurity and International Arbitration, this protocol sets out reasonable information security measures, particularly in light of virtual hearings and paperless document transfers through that application process, and also includes risk assessment and identification guidance on ODR processes. So these are protocols that one would need to be aware of if they're conducting a virtual arbitration. The ICC use of IT in international arbitration was issued in 2017 and also provides for some cyber protocol checklist. So a checklist prior to you going into your online resolution process, checking that all parties who are supposed to be present are going to be present that day, and who is able to be in the meeting and who is not allowed to be in the meeting, because you don't want to have people in your virtual room who are not supposed to be there. So that checklist is very important. Signing it off on technical specifications. Would we be required to produce documents? How are we going to project our presentation to the tribunal? Are we going to be using an electronic translation software? Are we going to have a transcript or a stenographer, an online transcript? What are the features and encryptions that are required that we're comfortable with? So all this checklist has to be provided for, and the tribunal has to be able to say, we are ticking these off, we are fully compliant, now we can go ahead and conduct our arbitration in a more conducive way. Now, I worked on the arbitration protocol on virtual hearings in Africa. This one was in April 2020, and that work was very, very fulfilling, because not only did we provide for cybersecurity features and standards, but we also had an annexure attached there that had tribunal issued cyber protocol. where the parties would sit with the tribunal and agree on the cyber protocol attached to their virtual hearing. So these are very important documents that one could look at, but there are many more that could also be found that have been issued over the couple of months that we have been through this pandemic, assisting parties to conduct safe ODR mechanisms and processes.
I'm very curious to know as to whether there is any provision if there are breaches of the cybersecurity standards. Is there anything to address that?
Well, if there are breaches by either party to the standards that have been adapted, well, one would say, with the agreement of the parties and having had the procedural order being issued by the arbitral tribunal, because the arbitral tribunal would not issue a procedural order that has not been agreed by parties, especially having had to discuss it prior to issuing the order of direction as to how you would be conducting your virtual hearing, for example. Now, if there are breaches to it, I think the arbitrators or the arbitral tribunal would then be at hand to sort of rule on that if it is brought to light by one of the parties that there has been this and this and this particular breach, maybe an aspect of fraud or fraudulent behavior by one of the parties. So this really comes back to the tribunal's discretion. Yes, Nabila.
Yeah, my answer. I got my answer.
Okay, thank you. Okay, so then before I move on to our next slide, I wanted to look more on the models of online mechanisms or online settlement procedures that one could have in place. And maybe also an article that webinar participants can look for is an article written by Colin Rule, Technology and the Future of Dispute Resolution, which contains the text-based and nature of online dispute resolution, help disputants better access information and correct misunderstandings. How? Because you are now online and you have either through email exchange with the mediator your mediation brief. Through emails, you have been able to discuss certain points of agreement. And so with these kind of exchanges, it gives the party a better opportunity to correct certain misunderstandings as opposed in face-to-face meetings where chances might have missed out during that process, or the opportunities might have been missed out during that process. And so if it is an email-based online dispute resolution process, that gives opportunity for parties to be able to really exchange and obtain more information than could have been in an offline environment. And so that article should be an article that one should look out for. So electronic negotiation is one of the first alternative dispute resolution mechanism in the spectrum on the non-binding end of the spectrum, ADR, and it's defined as the process of conducting negotiations between business partners, or it could be any partners really, using electronic means. The interest in e-negotiation is motivated by its potential to provide business partners with more efficient processing, enabling them to arrive at a better contract that they are discussing. Now, with e-negotiations, really, it's the non-binding aspect of entering into negotiations, parties trying to reach amicable settlement or amicable contract terms. And this could be facilitated by a neutral through an online either ODR platform, through emails, through other solutions such as closed closed chat rooms where you have the neutral negotiator assisting the parties to negotiate a contract of some sort, or negotiate a dispute that has a negotiation clause prior to either submitting the matter to mediation or arbitration. So could be also be done electronically. Online mediation, as we spoke and we keep speaking, is that this has been done over the years. Actually, with online mediation, I think it really just has picked up more pace than online arbitration because it mirrors the traditional mediation process, and not a lot changes in the process at all by the use of technology. So it could be initiated by email to the parties, containing the basic information or the mediation brief. And there are some certain automated software programs which have come about over the years, such as One Accord, Web Mediate, Internet Neutral, BB Online, for consumer disputes. These are just examples of mediation providers and service listings. Virtual meetings could be conducted in closed chat rooms, as I said earlier, which constitutes virtual versions of meeting rooms. The electronic tools enable increased flexibility because virtual mediation sometimes becomes electronic negotiation and vice versa. This was stated by these two scholars in their 2005 edition, Bellucci and Zeleknikov, if I said his name right. Conducted through text-based communication also, and meetings in real time, such as teleconferences. So it could be a mixture of the two. As I said earlier on, it used to be a mixture of online and offline solutions in order for one to carry out their practice. And I think, in reality, this has been the case. You would get a telephone call appointing you as the mediator. You will take it on and make your teleconference for your initial pre-mediation conference. And then, of course, come in real time, you can come have the physical meeting after. This is what we're used to. But now you can also have that physical meeting in an online environment. There's also greater flexibility when it comes to accessing platforms. If it's a PR provider platform, you can access it anytime, anywhere, and it's easy to use. If it follows the technical notes of the UNICITRO, it has to be easy to use, easily accessible, convenient, trustworthy, and efficient. Cost effective and cost saving is also a critical point when it comes to online mediation. Have that professional in an online environment, delivering the documents using the online portal that you have selected. If it's Zoom, you can share documents, you can share presentations with your mediator, and you don't have to do the printing, the heavy lifting of the documents and delivering them physically to their offices. That is now gone away with when we are on online mediation. Are there any questions on online mediation?
No questions so far.
So with online arbitration, and this is worth mentioning at this point, that the standard of English law has impacted upon several other jurisdictions. And the following words urged by a judge of a court in Sri Lanka are very characteristic. The judge said, the court has taken into account the changed circumstances resulting from the transformation that was taking place due to technological advancement. When we are barely a decade away from the 21st century, it would not afford, with reason, to interpret the concept of joint participation as being physically present together at one and the same place. Now, this was a judge in Sri Lanka backing the content that was coming out of the English law jurisdiction, that we have advanced and technology has advanced, and has taken us where the concept of joint participation is being presently together is no longer really something that one needs to interpret in a way that you have to be there physically. And online arbitration platforms have been around for quite a while. So they've been Resolution Forum, High Court House, the NAF, all these are arbitration services that are being conducted online and have been around for quite a number of years. And less, of course, it's less popular than online mediation, as I said earlier, because of the fact that even though it is allowed on the basis of the convention, the New York Convention, and directives on certain other electronic commerce, the EU ones especially, it has been less popular because of the hearing aspect. Hearing in arbitration is as if you are in a court of law, where you have to cross-examine the witnesses, where you have litigants use their advocacy skills to be able to obtain the witness statements to address the arbitral tribunal, just as that's in a court of law. So arbitration was leaning back to embrace online environment fully because of this aspect of the process. Whereas for mediation, it has picked up the pace and has proven to be more efficient over the years, and it has been globally embraced by mediators over the years for use as an efficient means of mediating cases. Now, with arbitration, as I spoke, is that in 2020, we have seen protocols being put in place that are now enabling parties to an arbitration to accommodate the four parties online or technology. For processes to be recognized as arbitration, it should compromise of the following elements: the mutual consent of the parties to submit to arbitration, the choice of the arbitrators, due process, and a binding decision. These are the four elements that need to be of satisfactory nature. So in order for you to have an online arbitration, all the features would have to fully adhere to. Now, consent of the parties would also include the consent to conduct it online. There are certain platforms where they offer automated contracts where we don't usually read these automated contracts. Uber is one of them, where they have an arbitration clause. So when you're clicking your Uber request and agreeing to Uber, you have an arbitration clause in there, and you have consented to it. And so therefore, in the day that you have a dispute arising via a certain organization that is online, then you go back to your terms and conditions, which are electronic in nature. You find an arbitration clause, and so you have mutually had proceeded to an online conducted arbitration. The choice of arbitrators, really, one would really look carefully to appoint arbitrators who are tech-friendly or tech-savvy, arbitrators who are able to use technology that would enable them to carry out cases online. So that's one issue that one would have to address, of course, along with the other qualities that you would look for in an arbitrator. Now we've added another quality, which is the use of technology. Due process, because now understanding that even though the arbitration is carried out in an online environment, we go away from due process. We have to maintain the requirement of the law for due process. Justice has to be in means that we all understand, meaning a fair process that is seen to be fair to be conducted by the arbitral tribunal. The binding nature of the decision or the award is also really arising from the arbitration laws of our country, where we find most of our arbitration laws providing for the final award being final and binding on the parties, and as good as the decree of the court jurisdiction, original jurisdiction. Then, in principle, really, parties can agree to conduct proceedings by online technology without an oral hearing. So this is a document-only arbitration, and a very good guideline is issued by the Chartered Institute of Arbitrators. They have a really good guideline for document-only procedure. So if not online hearing, then parties can agree to exchange the documents with the arbitral tribunal and have a document-only arbitration, similar to what the UDRP policy that is being conducted under the white law that I spoke on domain name disputes. That is really a purely document-only procedure, whereby everything is being conducted online, exchange of documents to the final decision. The analysis of the legal framework for online arbitration with respect to arbitral proceedings, as provided for under the municipal model law of the International Commercial Arbitration. So that also needs to be analyzed, and that would provide some guidance to those parties conducting an online arbitration. Amended UNICITRO regulations of 2010 consider the impact of the internet on the reality of conducting arbitration proceedings. And these are very crucial for those who are practicing arbitration practitioners or ADR enthusiasts need to be well aware of these UNICITRO regulations that are really going to give you some deep dive into conducting arbitration proceedings. And of course, the WIPO conducted electronic arbitration proceedings, as we spoke of earlier. So it could either be a fast-track arbitration, the document-only arbitration, or a non-binding arbitration as agreed for by the parties. And so these are the options that one could have in conducting a fully online arbitration. I also touched on the new development of smart contracts and the need that there is an arbitration clause in smart arbitration, a smart arbitration clause in certain electronically documented contracts. And these are translated into a block of codes or stored in a blockchain of some sort. And by their nature, an arbitration clause, it's really passive in nature. Then therefore needs to have the dispute that parties cannot otherwise resolve. It's only triggered when there's a dispute that the parties cannot resolve by themselves. A third-party arbitrator is then appointed, and this is all done by system or in electronic format. The third-party arbitrator is appointed automatically, reviews the case, and carries out the resolution. Either the arbitral decision might be registered on a blockchain permitting a self-executing arbitral decision. Now, this is self-executing nature of the arbitral decision. Certain blockchain platforms provide for this, whereby they would execute it against the other party in an electronic means, especially if they have bitcoins, and bitcoins are attached to that particular system. So those bitcoins could help in settling the decision. And the arbitration process would even be integrated within the disputed smart contract so that an algorithm could be used to resolve the dispute. Now, with an algorithm, this is an automated sort of, you would say, if I can call it some sort of bidding, or a document where it would work out certain solutions by the use of technology. AI, artificial intelligence, could work out and resolve the dispute by using certain in other words, maybe, which has fallen out of my mind, just certain appropriate solutions to the dispute by the use of the system itself. To work out a resolution to that dispute. And so blockchain arbitration is usually fully systemized and electronic in nature. These are the other innovative guidelines on virtual hearings, which we spoke about already, but I did not touch on the CIAB guidance, which is the Chartered Institute of Arbitrators guidance on remote dispute resolution proceedings using of commercial digital platforms. This particular guidance note does provide for a very good guideline for ODR practitioners, be it a mediator or an arbitrator. It seems to look at the dispute resolution proceedings in whole, and so therefore they provide a very good requirements. For example, making sure that you create an atmosphere that is approximate to the face-to-face proceedings. All participants should be visible and audible in the chosen virtual hearing room. So this talks on what requirements one would need to observe for that virtual hearing to be effective. The sole protocol on video conferencing in international arbitration also offers a recommendation for having a 360 room view. So when you've got your party sitting in their room, you're able to see in a 360 view sort of option. And then, of course, such portals can have a technical specifications for the venue and the ODR provider. So all these needs are factors that one would need to be able to look into and evaluate what is good for that particular arbitration. The hearing venue or remote venue. So with the SOAP protocol, it does have a requirement for a hearing venue that is a pre-approved venue, or a remote venue that is pre-approved by the parties. So this really offers a level of a higher level of requirement as opposed to the CAB and the other protocols that have been issued. And then, of course, an observer to be in place. This is also a very high level requirement. And so the SOAP protocol has its own features, unique features, which parties or participants who are wishing to be virtual providers should be aware of. The ICC checklist also requires the 360 view, agreeing to a list of participants, as I spoke of, knowing who is supposed to be in the room and who is not supposed to be in the room. It's very critical, and who is coming to do what, because some of them are expert witnesses, some of them are the actual parties coming to review the proceedings and so on and so forth. So blind bidding is another development that took place over the years, and it's been around for quite a while. And this is really a blind bidding procedure, and it's automated and facilitated negotiation. So what happens is that the blind bidding process, the parties are introduced in the internet. They introduce their offers in the internet, such as when you're doing bidding. The bidding process in traditional ways. So you put your offers in the platform that you're in, be it Resolve It Now, Settle Online, Smart, or Cyber Settle. Cyber Settle being the most common one. The offers of each party are not close to the other parties. Each party fixes in advance the ZOPA, which is the zone of possible agreement. The system compares the three offers submitted by each of the parties, and if one of them falls within the zone of possible agreement, the agreement is automatically fulfilled. So this is called blind bidding, and it's being used mostly by insurance companies, but now it has gone not only for insurance companies, but other nature of businesses as well, where one would be within the zone of possible agreement, and that system would pick it up and automatically conclude a settlement on those terms. I wanted to look at some cases that I came across when I was looking at the Indian jurisdiction. Some cases that have landmark status and have produced really, really interesting text. For example, the Tata and Sons and the Advanced Information Technology Association and the Maruti Audio Limited versus Maruti Software, where this is a WIPO case. The Arbitration and Mediation Center was made the medium to solve the domain name dispute. So the courts held that the WIPO was the right medium to solve that kind of dispute. And so the matter was shot off and taken on to the WIPO Arbitration and Mediation Center. The state of Maharashtra versus Dr. Praful Desai, the Supreme Court there held that video conferencing could be resorted to for taking evidence of witness by stating the recording of evidence satisfies the objects of Section 273 of the Code of Criminal Procedure, that evidence being recorded in the presence of the accused. Now, over the years, we've seen video conferencing being accepted very much so in many of our courts, and facilities have been put in place for us to now take evidence of witnesses by using video conferencing. In Trimax, the Honorable Supreme Court also of India held the online the most important document of arbitration. And since parties do not meet personally, but rather virtually, it is pertinent that the Supreme clearly defines all particulars of dispute resolution mechanisms. There must be meetings of mind, and the agreement must be according to the Arbitration Act. Now, this is also a very pivotal case for the India jurisdiction, where it has recognized the online arbitration. And the court has gone on further to say that the arbitration clause, the online arbitration clause that I referred to, has to be clearly defined, such as that in the traditional arbitration clause that we are aware of. Now, an online arbitration clause has different features, different requirements. Which virtual platform are we going to submit to? Understanding that is very important. In the last case there, the Shakti Dog Food Limited versus Polar Shipping Limited, the communication and acceptance by telex, telegram, and other mode of communication has been accepted as a valid mode of communication in an arbitration. And so therefore, this is really all pro-online ODR coming from our judiciary, and specifically the Indian jurisdiction. But this is not different from other jurisdictions. Other common law jurisdictions have borrowed live from the English to the India courts, from the other common law jurisdictions, and so therefore these are accepted means, and the courts have spoken to that already. Now, becoming an ODR expert, we've talked about the character of the dispute. Having understood your dispute, the dispute that has been tabled and filed before you, is it okay for you to conduct those proceedings purely online, or partially, or fully online? That is a question that one has to ask in looking at each case on a case-by-case basis. Personal features of the parties. Now, if we get a village or a farmer who doesn't use technology at all as one of the parties, then you would not be doing him justice, getting him in a very complex online environment where they have no idea how to switch on the technology that you have initiated. So therefore, you would need to look at each of the parties, their ability to use the platform, the technology, and so on and so forth. Not only the parties, but also their counsels. Now, we face a big challenge because lawyers are also falling back on use of technology in our jurisdictions, especially in Tanzania and East African markets. We need to enable our lawyers to embrace technology, use technology, and be able to say, yes, we can fully participate in an online arbitration or mediation. The negotiation style of the parties, the financial state of the parties. But some of these platforms are worth a lot, and so one needs to purchase a license. And so therefore, the financial status is very important. Time limits for the resolution. Would there be a time limit that has been incorporated into the dispute resolution clause? So therefore, that's one item also needs to be considered. Duration of the relations between the parties, level of personal and emotional involvement. So if you see a family dispute or a divorce mediation, it could not work well in an online environment if you try to. So if it's not going to, then you need to recommend an offline environment where you have more control, and of course the impersonal nature of it having broken apart in the sense that you would be meeting the parties on face-to-face. The level of conflict escalation. This is also coming back to the nature of the dispute, the character of the dispute, whether that has escalated to a point of very high level of the escalation graph. Having the right equipment as an ODR provider or an ODR neutral. If you're going to be conducting your neutral services in an online environment, you have to have the necessities, which is, of course, a laptop with you, with a microphone, a nice camera, secure internet connection is very important. Also, having the particular video conferencing facilities. You can pay for Zoom Pro, WebEx, GoToMeeting, Skype for business. You have to pay for the functions, because if you are going to use these, the functions for waiting room for the parties, so that you can hold the participants in a separate room before you initiate your mediation or before you initiate the arbitration. The participants are not able to see themselves prior to you inviting them into the room, the joint session. So this is very important. The breakout rooms as well, because some of these Zoom WebEx will not give you breakout rooms unless you have paid. The optional equipment as well, there are microphones, having your headphones, maybe to control the volumes, maybe another screen or two. I was involved in an arbitration where I had to borrow a few laptops for me to be able to have one screen with the transcript, one screen with the evidence being tabled, one screen with what was actually going on. So, you would need the resource for you to be able to do it. Or you can use your phone. So sometimes maybe the arbitration needs to chat with themselves. You can have WhatsApp as a group to chat, or there's a technical hiccup. So your phone comes in very handy if there's a technical hiccup and everybody falls out of the room, and you have no other way to get hold of them and get them back to the proceedings. So you have your phone in come handy. Your emails could also come in handy, and so always have a backup. So read the CEDAR. As you can see there, I got this essential equipment document from the CEDAR guide to online mediation, and they could be applied to also online arbitration. Thank you so much. I really enjoyed presenting today. A few recommendations for those who are spearheading ODR provisions in their countries. This is one, developing the first recommendation that I would want to put forward is developing the right institutional rules. Now, the rules have to speak to the environment. They have to speak to the actual realities of your location, your relevant jurisdiction. And so therefore, coming up with these rules would be very important for you to assist the parties who wish to use ODR technology. The second is knowledge and awareness. And that's why we're here today, sharing knowledge together and being able to build this education, advocacy, awareness, outreach, and marketing of online dispute resolution. If we want more people to use online means of resolving their disputes, then we need to do this more often. And I really, really commend the efforts of the CEDAR for coming up with these webinars and series of webinars which are focused on building our knowledge around technology and dispute resolution. Pilots. Now, we have not seen pilots a lot here in Africa. And so I would encourage for us to engage stakeholders everywhere, for us to be able to design pilots that could run from our different constituencies, to villages, so that we can give them that access to technology that we're speaking about. Ethics and security. This is always going to be remaining a critical issue in ODR. And so I want to say to those who aspire to be ODR experts, know your ethics remain the same as those ethics that you are to observe in your professionalism. As a mediator, as a lawyer, as an arbitrator, as a neutral in general, you must have the highest levels of security. You must ensure that you engage a platform or a portal or be part or a member of an ODR provider that has the highest end-to-end encryption security features, SSL, that you can come across. So these are very important. Also, we should, as institutions, come with unified guidelines, ethical standards, or codes of ethics of some sort that would now also give us some sort of direction where we're all on the right way. Lack of data and research. And this is really coming up from my work in 2015. When I started iResearch, I was trying to dig into research so that I could be able to formulate a strategy for iResolve, and I did not come about a lot of data. There was no information. The research was either not there or was there, but I couldn't access it. As an African based in Tanzania, I could not access it. So we need to create our own content. We need to create a platform that would have the content that is focused either in the more developed countries. There has been more data out there and information with respect to ODR as opposed to when we look at our countries. So the users need to also give us feedback so that we can improve the portals, the platforms, and the service that we provide as ODR providers. Institutional synergies. As you see me here today, I was approached by CEDAR to make this presentation, and these are the synergies that will really develop the practice of ODR. And so institutions and training providers should create these engagements, these systems, or these one-stop shops where participants who are interested in this field of practice could have access to the right information, access to the right connections and networks. And so, in conclusion, what I would say is that technology is no longer just about nice to have. It is a must because of what has happened with COVID-19, what we've witnessed, a technological evolution. We cannot say that the future is tech. We are saying tech is now. We need to embrace technology. Virtual realities are as what we are seeing, that the rise of cases of online distribution is happening. There's a survey being conducted at this point in time by the Delos Arbitration Studio. I think it's a firm. I'm not sure if it's a firm or a studio, but the Delos conducted a survey on the use of virtual arbitration or online arbitration proceedings over the last couple of months. What has happened is that there has been an increase of online dispute resolution due to this pandemic. And so we do not want to be left behind. And we do not want parties to be left with little option, but to adapt to either the virtual online proceedings, meaning that we need to ensure that we are embracing it fully. The key to success is the ability to use and be comfortable with the technology. And so for me, really, the advice to an ODR enthusiast would be to practice, to take it on themselves, to have practice, to formulate their way of being comfortable with the technology, because everyone feels the technology differently. I'm able to multitask with my phone, and I'm able to multitask on multiple screens, but not all of us can do this. And so therefore, formulate your own strategy as to how best online, being cooperating with all the parties, the tribunals, and their representatives, and don't forget the institution, because some of the arbitrations that we have are institutionally being administered. And so therefore the institution has to be in the light of all your planning as an arbitral tribunal to ensure that all these features are covered. Now, in the spirit of getting growth and arriving to the level of ODR cases within our respective jurisdiction, we need to keep on engaging governments to come up with the right laws, with laws that are not going to push us back, but they're going to be more futuristic as opposed to shutting us at one place. The lawmakers and the institutions, they must act quickly with this movement of the fourth party for this process to be growing and continuing to grow. And so what I would then say now is that this comes to a conclusion of my presentation, and I welcome all your questions. The last slide, of course, there, once we have the presentation, you will find most of the documents that I had gone through there. Thank you so much.
Thank you. We have a few questions. The first question is, do you think that there should be a binding guideline or international convention to address the ODR standards? Should it be binding?
No, I wouldn't want to agree to the binding to a binding standard, because we want that flexibility. We all understand this field of practice, ODR, is from ADR mechanisms. For example, mediation, we have left them to be as flexible as they can be. Some, of course, they have regulatory frameworks attached to them, but even those regulatory frameworks against mediation, you can see the laws are very soft in sense to allow the neutrals to maintain flexibility, to achieve flexibility. And then, of course, when we come to arbitration, we are aware of the laws that are attached to arbitrations that we're conducting in our respective jurisdictions. And so therefore, those laws in respect to arbitration, in respect to mediation, if there are any in your country, those will be directly linked to the process that you'll be conducting in an ODR platform or an ODR process. And so therefore, I think the process itself is really the procedure, and the procedure itself should be as flexible in order for you to be creative and engaging your parties. You're able to create solutions as and when a problem occurs, because you might need, for example, you might think that when you're learning mediation, they tell you that there's usually a room where you can go and just reflect and relax and maybe meditate, to get yourself back to speed. So how would you do that in an online environment? So then you can create a fourth break. So you have a room for your plaintiff, a room for your defendant, a room maybe for the lawyers to talk about whatever they need to talk about. The lawyers could also, have their back and forth in their private section. You could also have a fourth room where you say, this room is the coffee room, for the parties to just go and have a laugh. Because you do not want the whole day to be online, very stiff, in a mediation, without any period for parties to relax. Even in an online environment, you can accommodate the coffee room. Because the coffee room gives you that room to build that
Atmosphere.
momentum and rapport. Yes. And so I would suggest, and I would recommend for flexibility to be preserved. And so the soft law approach, the self-regulatory approach that we are seeing over the years, over the 90s and 2000s and now, I think this is the right way. And that's why you see that the virtual protocols that have been issued are just virtual protocols. They're not rules. They're protocols. They're calling them protocols, guidelines, notes, and so on, because they want that flexibility to remain present for parties to be able to explore. Because each and every day, there's a new portal coming up. There's a new portal that does technology in a different way that the rules never thought about, or the protocols never thought about. So we need to embrace technology as it is, and that is constantly changing.
Okay, so our goal is to keep the whole process flexible, and that is how we will ensure the access to justice for all the parties involved. Okay,
Yes.
we have a comment. Usaje Mamwanbi writes, indeed, this is a very insightful session. Thanks to the organizers. How do we make our lawyers or mediators be more trained technologically?
Thank you. And that comes from one of the members of our governing council at the Tanzania Institute of Arbitrators. Thank you, Sajid. Thank you for attending as well. Well, how then do we create the awareness, the level of training, the level of capacity building that is required? Now, really, it's the interest. Can we have enough interest for lawyers to say now that we need this kind of training? Now, different cultures accept learning in a different way. So in our environment, of course, Tanzanian lawyers are ready to learn. Tanzanian lawyers are equally equipped to learn because they have been using technology throughout their careers as lawyers, from the initiation at being in the universities, attending to their law degree. But now taking it up as a means of practice, this is where the question is. If one decides that I want to become an ODR expert, then you can channel your path. And I like the title of this webinar because it's halfway to ODR expert, to being an ODR expert. Pathway. There's always a path one will create. One, taking initiative is that you learn it as you practice it. The second is you learn it as you research it. So reading. We don't have a culture of reading in my country. But if we do, people will read and people will learn. Now, creating awareness for the use of technology is something else. And these are institutions such as CEDAR, such as TAB in Tanzania, such as NCIA in Nairobi, such as Singapore in the Singapore Arbitration Center. They need to create awareness among their lawyers, the practitioners, that this is the future of dispute resolution. And so therefore it is a requirement under your continuous learning education that you have conducted a training in the use of technology. That's one way of getting lawyers to speed. And I think in my country, that's one way, the only way to get lawyers to speed. That one of those CLEs, we call them, for you to be able to renew your practicing certificate, you must have conducted a training on technology in the previous year.
Great. This brings us to the end of our webinar. I thank you for taking the time for arranging and coming to our session. And it was an absolute pleasure for me to host you. I think it was very enriching, and not just me, everyone who was attending this benefited a lot. And I wish you all the best for the future. Do you have any last minute message to our audience?
Thank you so much, Nabila. My last message is really a thank you note to you all. I wish you all a wonderful rest of the week. And I wish you all a very inspiring week ahead, an inspiring year ahead, where we have to now realize that we are now working in different times where we have to observe social distancing and and that social distancing precaution will have to get us to embrace technology. And as we are doing this webinar, I am based in Dar es Salaam, Tanzania, and I welcome you all here in Tanzania in the near future to explore the wonders of the tallest mountain, Mount Kilimanjaro. Karibuni sana.
Thank you so much, Madeline, and thanks to our audience. We hope to see you soon in another live session. Until then, stay home, stay safe.
Thank you, Nabila. You too.